Welcome to Money Market, a Bank of Tampa podcast. And I've been asking for every episode for some sort of feedback or suggestions, and I finally got one. So thank you for your comments, although I'm not certain I'm crazy about it. But Owen, when you do the introduction of the show, it looks like you are falling asleep and you have your eyes closed. Try doing it looking at the camera. So thank you for the suggestion. We will give it a try. So welcome to Money Market, a Bank of Tampa podcast. We highlight the businesses, business experts, the local economy, and points of interest in the Tampa Bay community. Follow us on YouTube, Spotify, or Apple, or wherever you find your favorite podcasts. Please be sure to tell a friend or colleague. I am Owen LaFay, the Pinellas County Market President for the Bank of Tampa, Tampa Bay's oldest and largest community bank. There, I did it. And today we are joined by Todd Cordell, who is the head of the Bank of Tampa's Trust Department. Talk about all things estate plans, trust administrations, estate settlement, and everything that's trust. So Todd brings 30 years of trust industry experience working in really all banks, community bank, mid-sized bank, and large banks too. You've been just involved in everything from the front office to the back office, which makes you, really one of the most rounded trust experts that I've had the privilege to work with. You've got a law degree from DePaul University in Chicago. We're thrilled to have you leading our trust department here at the Bank of Tampa, and there's not many people more than I trust. See what I did there?
Nice one. Good one.
Then Todd Cordell, I'm sure you hear that all the time. But welcome to Money Market.
Thank you. Thanks for having me. I'm happy to be here.
So these are one of the topics, being trust administration, that a lot of people don't know much about until you need to. So can you kind of tell everybody what you do?
Sure.
I know it's a big question. But
it is a big question. I get this question a lot, and it's hard to put it into a real easy nutshell. So if I take it from a very high level view, talking about we are a fiduciary. So clients are entrusting us with property to handle that property, maintain it, and invest it for their benefit going forward. With that, we have certain responsibilities that we take very seriously. Duty of loyalty. We are there to maintain the property for the client, for their best interest. We can't do anything.
And by property, I mean whatever that. So asset, real estate.
Absolutely. It could
stocks.
Be cash, marketable assets, real estate, personal property. You want to get down to, sometimes we have boats, sometimes we have cars,
Sure.
and artwork or collectibles. So any sort of property. And so we're entrusted with the care of that property. We have a duty to maintain it, a duty to make sure that it is preserved, and then duty to use that property in the best interest of our client. So when we translate that into what we do from a trust perspective, we're acting as a trustee. So we have a trust document that names us or individual as a trustee. That person or entity then is charged with making sure, again, we're investing that property. The property is being used, again, best manner for the individual. Also, make sure that the document is being followed. The trust is a very powerful document. If I create a trust, I'm explaining to the world, this is how I want my property to be administered, not only for me, but for maybe my children, my family, charities. And that trustee has the sole responsibility of making sure my wishes are followed.
So what if the document is inconsistent with what you believe is in the best, doing the right thing, the best interest?
So if we have a trust document that says, example, we see this quite a bit. We have young beneficiaries, and there can be terminology in the document that says you can make distributions for the best interest of my child. And a child comes to us and says, I want a car. Give me the latest and greatest, Tesla truck out there for $100-something thousand. maybe not the best thing for an 18-year-old
Well, how do you
kid.
define best interest then in that instance?
So, best interest, you can go. What we do is we go to Florida statute, or we go to case law that says here's what best interest means. But best interest is really kind of broad. But then we have to put it into real world terms. Here we have an 18-year-old kid who probably can't get insurance for that car, isn't going to have funds to maintain that car, and may have to keep coming back to the trust and basically draining the trust on a somewhat frivolous purpose. We can get another car that's workable, that's not going to cost as much, and he might be able to maintain it on his own. So there's a balancing effect between what the document says, what the beneficiary wants, and where's that middle ground.
That sounds, it almost reminds me of, being in banking, I get to look at loan documents all the time and agreements and reasonably. I mean, attorneys love to throw in reasonably, and like, how do you define reasonably? And I've been in a courtroom for 18 months arguing over what reasonably meant in various instances. So is it, maybe comment is the wrong term, but does it come up where someone then sues the trustee because they disagree what best interests are?
Yes, it happens.
Okay.
So in my experience, again, I'm working for an entity, so I take it as I have 3 clients. My employer is a client, the trust document itself is a client, and then I have my beneficiary who is a client. And you have to balance all of those. Nowadays, you can get sued for anything.
Yeah, that's true.
So how you protect yourself or nothing. And in some cases, it's reasonable. Maybe the trustee is being unreasonable and just not.
That Tesla truck will last forever, man. It's never rust.
Right. And so you have to balance that, and you protect yourself by, it's in any business, you document.
Yep.
It's not the actual decision that can get you in trouble. It's the process of how you came to that decision and the, again, reasonableness of your decision. So we could spend the $100,000, buy the Tesla truck, give it to the 18-year-old kid, and then he trashes it for the remainder beneficiaries who stand to take after the child or the younger kid could come back and say, well, you shouldn't have ever done that. We just have to be able to demonstrate why we think that's a reasonable decision.
Got it.
Which is to protect ourselves. We could get sued, but then if we go into court and say, here's the process that we went through, this is our logic, it's going to be hard for us.
A lot is reliant on the document then.
You're relying on the
documents.
document, absolutely.
So what do Michael Jackson, Heath Ledger, and James Gandolfini have in common?
Either no document or bad documents.
Okay, so it goes back down to the document.
It goes back to the document. It goes back to really having a plan. When you talk about you see those high-profile estates. Prince is another one where his estate, he didn't have one. And people came out of the woodworks and got money from his estate. You want to have an estate plan. It's important for everybody to have it because that estate plan kind of works with you during your lifetime. And so in a general estate plan, you should have 4 to 5 documents.
What are those?
That's your power of attorney for property, your power of attorney for health care, a trust and a will, and then there's also a living will. Your power of attorney for property is really only effective during your lifetime and if you become incapacitated.
Okay.
You're giving somebody the authority to make decisions on your behalf in regards to maybe it's a piece of real estate, maybe it's a bank account or something like that. But it's good to have in case you become unavailable or incapacitated, that somebody can get access to funds or access to your property to use in your best interest. Healthcare is the same thing. You want to make sure that you have somebody who can make good decisions for you based on what you're telling them and based on what you're putting in the document. I don't want to go into a nursing home. I want care got to the house and give those persons the ability to make the decisions.
You're hoping that person loves you.
Exactly, yes. And that there is not some ulterior motive behind
the
scenes. Yes, absolutely.
Pick wisely.
living will, you're talking about do not resuscitate, I don't want feeding tubes, kind of more of those spur of the moment emergency situations. But you want to have somebody who will make those decisions for you. Otherwise, it gets messy. Your trust is, as I said before, is the most important document. It's very powerful. It's effective during your lifetime. It's effective during your incapacity, and it's effective after you pass. Whereas power of attorney is effective during your lifetime and incapacity. Once you pass, those are no longer effective. Your will, and you know everybody relies, I have a will, I have an estate plan. A will is a great start. Mm-hmm. It's not complete because your will is only effective after you pass.
Right.
And so I think when people put together their estate plans, and it's human nature, nobody wants to talk about, well, I'm going to be incapacitated for a period of time.
Is it one of those things like life insurance, right? No one wants to talk about that because no one wants to think about the point in time when they're dead. Well, also like incapacitation, death. I mean, so when you sit down with someone and you're like, you need an estate plan, you need a trust, you need a will. I mean, is there like a natural hesitancy to be like, I'm good with a will. I don't need to worry about this other stuff.
Yes.
Okay.
You get a lot of it, I have a will, I'm good. And then you bring up, well, what happens if you become incapacitated? And then sometimes you get the pause, it's like, oh, I didn't think about that. Or you get the, I'm good, I got my powers of attorneys, which, again, may work. You want that complete plan. The trust is really the key for that. So I don't want to discourage anybody from saying, nope, just go get your will. And have your powers of attorneys. That could be very sufficient for each individual. You have to tailor your plan to your specific needs.
So how do you individually help people make an impact on their lives? What is your role kind of within that holistic approach?
So a couple different things. So if it's just somebody that's coming to me and saying, I'm considering putting together an estate plan, one of the things that I'm going to talk to them about are these 5 documents, how they fit into your life, and why they're important for them. And those conversations are very impactful because a lot of times it's like, I didn't know that, or I didn't know that, my will doesn't cover incapacity or something like that. So I think that has a big impact on it. When we're acting as a trustee, the impact, again, it varies. But let's say someone passes away. It's kind of sudden. And you have an entity or somebody else that's named as the personal representative of the will or a successor trustee. The impact is that person or entity can step in and start handling things that need to be done. Mm-hmm. Gathering assets, looking at what sort of property is out there, coming up with the plan while allowing the family to grieve and take care of family things. I don't think people understand how much work is involved being a trustee or being a personal representative. I always put it...
Gosh, well, especially if they have, a lot of assets and it's complicated, right?
Absolutely. Even if you don't have a lot of assets, but the concentration of assets could be different. I've seen estates where very real estate heavy. That is a full-time and a half job to handle several different pieces of real estate at a time. So imagine one of the things that I think individuals don't understand when they put together their trust and they name a family member. My son is great, my daughter is great, they'll be able to handle it. Well, let's say they have a home here and they have maybe a vacation property somewhere. Well, they're responsible for making sure that those homes are secure and maintained.
Mm-hmm. Payments made, yeah.
If they need to be sold or if there's loans or anything, they have to make sure that they're kept up. We have property managers that do that on a full-time basis. So if you have your own family, your own house to take care of, that's 24/7 job. When are you going to fit in the time to do this for another family member?
So is that the benefit of having a bank versus an individual, a family member as trustee?
Yes. One of the benefits is this is what we do. If every family got along, if every estate plan was real simple and...
Families don't get along.
Everything, kosher, everything works, nobody would need us. Yeah. But that's just not reality.
Man, that is not reality
We're
for sure.
humans, and everybody has their opinions and how things should go. Having the corporate trustee, that neutral party, who has a responsibility to do what's in the document, not what one family member says over another, is a huge benefit. The other is experience. Again, I've been doing this for 30 years. I've seen a lot. I'll never say I've seen it all, because I say that and then I'll go downstairs and there'll be a phone call saying, hey, this just happened and I don't know what to do with it. But we've seen a lot. And I think in our industry, experience is key.
I want to know what you've seen, Todd. What is give me a crazy scenario that you're like, this could never happen.
So I'll say this. I had, when working in Chicago, I was younger, working with a
Even
family.
better. It's not local. No, don't
No
share
local,
names.
No, working with family. Family was fantastic. They're really nice, and I got the opportunity to work with them and know them. My boss at the time was handling the relationship, because it was a big relationship. Everything was fine. Boss comes into the office, and she's very stoic. One of the smartest people I ever worked with, and she's crying. I'm like, uh-oh.
Oh, man. Yeah.
That's not good. And she explains to me that one of these family members that she's known for 20, 30 years took their own life.
If
And so I'm all maybe 30. I kind of took a step back, and I'm like, you take 10 seconds to figure out, okay, this is horrible, and then you got to go into trust officer mode and start thinking about, what do we need to do?
Right.
The house was an asset of the trust. The family has relied on us solely to take care of everything. Very, very family office sort of aspect to our relationship. So we've got to call the police. We've got to get people out there to secure the house and everything. So that happens, and I don't think people really grasp at that. But we have to step in. We've got to do this. Some of the more mundane things is, there were storms, and I'm checking on houses, and a lower level is filled with water.
yeah.
Call up.
Very common in Florida, unfortunately.
Yeah, call up all the places to clean it up. Nope, because everybody else's house is flooded, and so. All right, there's a shop vac, there's a bucket and a mop, get to work. And so shop vac it up and clean it up, pull out the carpet and all that stuff. So if there's nobody else to do it, we do it.
And I have to say, kudos to the trust team, because countless stories of those type of things happening, or going in and having to clean out property of folks that were just hoarders. And yes, it's full service, really. You roll up the sleeves, get your hands dirty.
Yeah, and larger institutions have groups to do that, but you still have to do that. If you work for community banks, it's the trust officers that are doing it. And in Florida, hurricane season. So one's coming, we got to go to every single property, make sure things are locked down, secure. That's what we do. Mm-hmm. And we do that for our own families, but we're doing it for the couple hundred families that we're already working with. So it's very personal. What we do, we get involved with families. We know these families well. I've had instances where I've had clients for 10, 15 years, and they pass away, and you feel like you're losing a family member because you've known them for so long.
Sure.
It's kind of that. This is a business for us. That's the reality of it, but it's very hard not to occasionally become attached to some of these people.
Sure. So I say this tongue-in-cheek a little bit, but has anybody left assets to their animals that you were involved with?
Yes.
Okay. All right.
So it's funny, and I guess I could turn this into a crazy story. I met with someone who she said that she had a trust, and she said it was a special needs trust. I said, okay, that's, those are important. She should have those. And when I met with her, she was going through, and she said, she had some birds that she had made provisions for in her trust. Then she came to the special needs part. And she said to me, she's like, so I have a special needs turtle. And so paused, and I'm sorry, did
Tell
you
me
say
more.
turtle? And she said, yes, we have a special needs turtle. I'm like, well, I've never heard that one before, but she made provisions in her trust to take care of the special needs turtle. I don't know what
So what made the
qualifies
turtle-
as a special
Okay,
needs
all right.
turtle,
So
but
took
she
the words
did.
out of my mouth.
Yeah, but she had provisions in there.
Turtle with a disability.
Yes, and take the turtle is supposed to go to I'm gonna mess up the word, herbivore society or something, and she had it all laid out. And
Is
then
that a
there was
thing?
money there
Is that like some sort of sanctuary for
Yes.
herbivores? Okay.
for turtles or lizards or something, and
Okay.
she had funds set aside to take care of the turtle for the turtle's lifetime.
Okay.
Turtles live a long time. So,
They do. Man, so
so-
do some birds. I mean, cockatoos live, like 80, right?
Yes. So that I would say that's the strangest with animals, but I have seen trusts for pet trusts. Nothing to the, I think it was Leona Hemsley who was the most famous one, but nothing to that degree. But I think
It's a little unique, yeah.
I know Illinois, it's in their trust code. They have provisions when you establish pet trusts. I haven't seen that for Florida, but I'm imagining there is something there. But yeah.
We're in Florida. There's definitely something there.
Yeah, I'm sure there is, and rightfully so. People, they don't have children, and their pet is
yeah.
their companion. Okay, within reason, take care of the pet.
I've been around in this. I'm going down the rabbit hole a little bit, but some elderly family members that have gone out and got animals towards the tail end of their life, and just I get it. I get it from the comfort level, but someone's going to have to take care of that animal afterwards, and who does that if you don't have any close family by? Who takes the dog? And then too often they end up at a humane society, and then they're maybe they're too old at that point, and they're not adopted. So happy ending for the turtle and for the birds.
Yeah, so the turtle and the birds, it worked out well. I will say I do appreciate the clients who think about that, because you're absolutely right. It's passed away unexpectedly, and you've got a couple of cats or a dog or something. Well, what happens to them?
Right.
So I appreciate that people have the foresight to think, you know what, I'm going to put something, whether it's just a matter of we're going to send the pet to this person, or it's going to go to this society or something like that. That's great. Trust officer's responsibility to
You got to figure
get
that
them
out.
there,
That's
but
right.
the fact that it's there and gives the trust officer direction, that's the key.
Yeah.
So,
Going back to estate plans.
Yeah.
So how does one go about setting up an estate plan?
great question. So I brought a prop.
Okay.
This is blank notebook.
Yes.
This is the start of everybody's estate plan, right?
There's not a template.
Yeah, it's a
You
template.
can't start from a template. We're starting from a blank sheet of
You're
paper.
starting from a blank sheet of paper, and this
Okay.
is what I recommend for everybody: is start with a blank sheet of paper and just start writing down the things that are, number one, important to you, and number two, what do you want to see happen? And that helps kind of shape what should be in your trust, what should be in your will, and it's a good way to map out, again, what's important to that person. So I always say start there. Then have a little bit more, you take a look at what you've written down, and then now try to start applying that to your real world situation. Nobody is the same. No family situation is the same. So the best estate plans are tailored to meet specific needs.
Sure. Yeah, it's not a one size fits all.
It's not. I would say there are, in every trust document, you have your boilerplate language. Right, that needs to be there. But when you now get to the point of, I'm distributing assets, or I want assets preserved for me to take care of me, it should be as specific as possible. And it should be the way you want it. I always tell everybody, you have funds and you created a living, created a lifestyle for yourself, and you want to pass that on, you earned that. You should have that money or assets, properties, whatever, pass on the way you want it to. You don't want somebody to dictate to you, again, if you don't have a will, that's fine. Florida statute or any state statute is going to tell you where it's going to go. Mm-hmm. It's probably not where you want it to go.
Right, it goes to probate. Then,
you go to probate. And probate's, people say it's a bad word. It's not. Probate is great. It's necessary. if you can avoid
Is it great? I mean, it's necessary. I don't know if it's great.
It's necessary. I think I'm talking from somebody who's working for an entity that likes to be protected. Probate is great because we get covered on it. So if you're in that trustee role or personal representative role, probate's really nice.
With a document, a plan, right?
Yeah. So even if there's not a document, you still want to make sure that you're getting enough coverage. So it protects you against our early conversation, somebody coming back and saying you shouldn't have done that. Well, the court blessed it. We're good. Probate, not evil. So, I think it's a necessary tool. If you have that trust, you can avoid probate. And that just when you avoid probate, you kind of speed things up. With probate, you're looking at least 6 months because that's your initial creditor period. It could take longer depending on the composition of assets that are in the estate. I'm not going to say that a trust is going to speed that up. When we talk about administration, I used to say 6 to 9 months. Now I say 9 to 12.
Okay.
But again, it all depends on what the composition of assets. If we're sitting on cash, real easy. Right? If we're sitting on 5 pieces of property that need to be sold, it's going to take some time to get that done. So it's really the composition of assets. And what does the document tell us to do? Do we have to sell those properties? Does maybe, one of the siblings wants a piece of property and the other one doesn't, and we can divide it up? That's why I say when you're putting together your trust, you really want to make sure it says what you want it to say. We talk about how we make an impact. Another way that we make an impact is we'll review existing documents and go back to the client and say, this is what it says. Does that meet what you want it to say? 50% of the time, it's like, no, it doesn't. Or, you know what? Things have changed. And so that periodic review of a trust is just as important as establishing one. Too many times you see that someone comes to us and says, yeah, I put the trust together. Great. But it's 20 years old,
right?
15 years old.
So you do that review for them?
Sure. We'll take a look at it, we'll review it. And again, when we're doing the review, we're not doing it from a legal perspective. We're not saying, yep, this is how it should be written. What we're taking a look at is, if we step in as trustee and administer this document, this is what it says, this is what we'll do. Does that match what you want it to say?
Got it.
And does that match your current situation?
Okay.
If it does, okay, maybe you don't need to make any changes. If it doesn't, probably need to go in and make some changes. And that's where you get the attorney involved.
Yeah, see, I mean, you are not doing that work by yourself, right? So you're coming from an advisory capacity and just saying, like, hey, what you told me is not consistent with the document that you have here.
Yeah.
Let's bring in a trust attorney and make the changes appropriate to what your plan is.
Absolutely.
Okay.
Yeah. It's when you're working on a trust, the best scenario is to have a team of people around you. You have your estate planning attorney, an accountant, you have a financial advisor involved, your trust officer. Have that team around you. Everybody kind of understands what the plan is, and so that they're all working at different points in the life of the plan to make sure your wishes are met. That's the key.
So, and I imagine that sometimes the beneficiaries are not happy with the document, and there are conflicts and arguments. So, how do you get involved and deal with that?
So, our duty is to the doc. We have a duty of loyalty, and we have a duty to act in the best interest of the beneficiary. As we talked about, shockingly, not every family gets along. And so we have to make decisions as to what's best and what's going to meet the wishes in the documents. It's difficult. A lot of squabbles that we see involve distribution of personal property. And years ago, and I will never forget this, I went to a estate planning seminar, and an attorney that I respect very highly was giving a presentation on estate settlement. And he came out and he said, I'm going to tell you right now, and you can tell all of your clients, those Yadros and those little Hubble statues or Hummel statues, are worthless. It's not worth the fight. And that's where you see the squabbles. And so we have to go and say, look, you're going to start fighting over this. And the reality is we can make a decision. You may not like it. We're going to end up in court, and we're going to spend thousands of dollars over this piece that may be worth $100.
Yeah.
So when you start to explain it in that sense, you sometimes get people to back off. And
if you had to throw a percentage on that, because people can be emotional and irrational.
And you are dealing with that. So even though those Yadros, the little statues, are not monetarily, no value, that emotional attachment is really hard to get over. So photographs are always difficult to deal with. So going back to when you establish that estate plan, that's something in an ideal world is already addressed. The grantor, the settlor of the trust, and the estate.
Photograph in this day and age. I mean, just make a copy, right?
No, people want
the original.
They want the original because you say that, and that was an instance that we had. Is we were going to make copies for everybody, and it wasn't satisfactory. People wanted the originals. So nowadays it's a little easier because it's
digital,
all on
right?
your phone.
Nobody prints anything.
Yeah, it's all on your phone.
Yeah.
And so one of the things that you start to see now are digital assets, provisions in trust and wills that deal with digital assets.
Yeah.
Older documents don't have that in there, so we always recommend that. You have, social media accounts, so you have photos and stuff on your computers and stuff. Make sure that you have those digital asset provisions in your trust and will. It's important now.
Okay.
It's just and it helps us when we have these squabbles.
Yeah. No. I mean, I get it.
Ultimately, sometimes I've never done this, but I had a colleague. They flipped the coin. And that was how they settled the disagreement between a piece of property. And the one beneficiary who didn't get the property, he was okay with it.
Okay.
So,
in some instances, have you seen where a wealthy person passing has created an endowment, and how does that work? I mean, do you as a trust administrator like set up the endowment? Have you been asked to run the endowment? I mean, I'm sure there's a number of different scenarios, but can you share some of that? Yeah.
So when you're doing endowments or you're leaving a charitable distribution, endowments, we won't get involved in the management of the endowment. We're more involved on the investment side of it, managing the assets, making distribution.
Okay.
When you establish that endowment, you're either going to, name a committee of family members or something to decide, who's going to get paid out or what the criteria is for making distribution. Or it could be very simple. You're just going to pick the local charity and they get, 5% a year or something like that. Our involvement really is just more of managing those funds and then making sure that distributions are made, filing tax returns. This is another point of what we do that people don't really think about is if you have a trust, a irrevocable trust, or even an estate, you got to file a tax return.
That's right.
That.
Yep.
And it's not like filing your personal income tax return. So that, as a trustee, we're responsible for doing that. We run into instances where we're named as a successor trustee or we're taking over for an individual and they haven't filed a tax return because they didn't know anybody.
Okay.
So that's where that experience. So you got to go back
yeah.
and kind of recreate and file tax returns.
Yeah, that's messy.
Just, again, that experience that we have is just key. Same thing on the endowment side of it. Experience, making sure, we're doing the tax returns, we're doing the investments, and we're making the distributions. If we have to, I've seen charitable trusts where there's a committee that is established and they decide, who's going to, get the distribution. But then there's criteria established that, it has to be a 501c3 or it has to be in this particular area. And so we're just kind of monitoring to make sure that committee is selecting people pursuant to the trust. You see more and more of that lately, which I think is great. Mm-hmm. That you're starting to see people really consider, charitable donations or charitable bequests in there, or establishing a foundation to make those charitable bequests. That's a great way to leave a legacy.
The legacy, right?
Yeah, and so going back to that blank sheet of paper, that's something that you see on there. I want to leave a legacy, or I want to give back to the school that I went to, or something like that. Great. There's ways of doing that in your estate plan. And it doesn't have to be elaborate either. You can establish that pretty easily.
So I want to close on just emerging trends you're seeing in the industry. You mentioned digital assets, but anything else? Is AI coming into play yet? I mean, what are you seeing? And
AI is something that I, as someone been in the industry a little bit longer, AI is a little hesitant on it. But I think what AI can be good for in estate planning, it's definitely there. It's starting to play a role. I think with AI, the good thing is you can go, like I talk about that boilerplate language. AI can help you get that state-specific boilerplate language. But I go back to what I don't think AI can do is make that trust specific to your situation.
Sure.
It's pulling out from a general world. So it might be able to give you kind of the corpus of the trust, but the specifics of how you want things distributed, that's got to come from you. So, but it's out there, and I'm seeing more and more presentations on it. I just read something, and I didn't finish the entire article, that a judge used AI to help write an opinion, which I find frightening. But I don't think there was any ethical breaches there, but it's because he disclosed it. But I thought that was a little
wow.
frightening.
I hadn't seen that one.
So,
that's pretty wild. So we're there.
The other thing I think is kind of important, if everybody knows this, we have an election coming up, and in 2025, the current tax plan, the cuts that were put in place, expire. And one of those is the estate tax. And I think it gets cut to $7 million, which is still a nice number, but not the 14 or 15 that we have currently. And so that, for the first time in my career, I've heard that there is a possibility that that's actually going to happen. So nobody can predict that, but it's something to keep into consideration. Because if now, let's say your estate is $10 million, you are fine. You're under that estate tax. Today. If it sunsets, now you've got to maybe go back and do some planning. So we are starting to see people do some planning. Seeing a lot of, they're called SLAT, Spousal Lifetime Access Trusts, which can move money out of your estate, but then it's still there for spouses to use. Great tool. There's some pros and cons to it, but it is a really effective tool. So we're starting to see that a little bit more.
Okay. So get your 4 documents in place. Get your experts around you.
Yeah.
Todd, if people want to find you, where do you want them to reach out to you at?
So you can reach me via email at tcordell@bankoftampa.com, or call me directly at 813-998-2711.
All right. Well, Todd, thank you for coming on Money Market.
Thank you.
If you have a question or a future show idea or would like to be a sponsor, you can send us a message at moneymarket@bankoftampa.com, or find us on LinkedIn, X, Facebook, and on Instagram at Bank of Tampa, and online, of course, at bankoftampa.com. Thanks for tuning in. Thanks for subscribing, and we'll see you around in the Money Market.